Hello and welcome to our webinar today. My name's Emily Southwood and I'm a trainee in the Private Wealth and Inheritance Department. This is my colleague Piers, who is also a solicitor in the department.
Good morning.
Today we're going to talk about some myth busting. So there's a lot of questions and a lot of misconceptions around wills and estate administration. So we're going to run through a few of those today. We've got 10 to go through with you, and we're going to hopefully help you separate some of the fact from the fiction about these misconceptions. So I will jump straight into it and I'll pass over to Piers for the first one.
So one of the most common ones that a large member of the public alarmingly seem to still think, along with common law marriage that we'll be touching on a bit later on as well, but is also that when you don't have a will, that your partner will simply automatically inherit your estate. So whether that's a long-term partner or a short-term partner, many people seem to feel that is simply just an automatic that just fills in automatically. Now, unfortunately, the institution of marriage exists for a reason, and therefore, if you are not married, that is not the case. So if you are to die without a valid will, your estate is unfortunately not going to automatically pass to anybody, and except under the intestacy rules. So there's a statutory set of rules in which your estate would then pass. So if you obviously are quite keen to name somebody, then what you should do is very much prepare a will. Sounds obvious, I know, but that is unfortunately what one has to do. If you, for whatever reason, do not wish to draft a will in any sort of way, the only way to provide for your partner automatically on that point, if you were to die intestate, is to unfortunately get married. So those are the two first steps, really, if you want to ensure that. And that's really what we've got here. So obviously, here's the issue, and here's the reality on the right here, and the only fix is to do either one of those bits there. So another common one over here.
So our second myth we're going to run through is that my partner will be able to deal with my estate. So it's slightly different from that first one. It's not who's inheriting, it's who can deal with the nitty-gritty of the estate administration. So often people assume that their partner will be able to deal with everything, deal with their estate after they've passed away, whether they're married or unmarried. And that isn't the case. So the reality is that where there isn't a valid will, the law sets out a strict order of priority about who can apply to administer that estate, and that person would be called an administrator. A cohabiting partner may not be entitled to apply. So even if they're the closest person to the deceased, that doesn't count for anything in these rules. It is a very strict guideline on who can make that application. This creates practical difficulties. So a lot of couples live together. That's perfectly usual. And actually, that person they live with might not be able to deal with the day-to-day tasks like paying bills, which the partner may have paid beforehand, or if it's not a property that they own as well, there's issues to do with whether they can remain living there, depending on family circumstances. So the only real fix to this is to make a valid will, appointing an executor who will then be able to administer their estate. Making the will means that you can actually appoint a trusted person, before you pass away, who would be dealing with your estate. And it just makes things a lot easier for the family as well, in terms of being able to carry out the wishes that you had. And the executor can be anyone you choose. So often people choose their partner to be their executor in the first instance, and then just creates clarity there.
Just adding on to that is that with dealing with the estate, if you were to be intestate, once again, as we touched on before, highlighting the intestacy rules set a very strict criteria who can apply to fulfill that role. And so therefore, without appointing anybody yourself in a will, you're very much losing any of that sort of onus and ability to choose who that is for yourself, and sort of defaults to a very set criteria. And so, as Emily said, if one wants to sort of name somebody in particular, one really does have to draft and prepare a will. Otherwise, it will default to the standard there. Coming on to the third myth here, we have once again a fairly classic one that many people would hopefully be more aware of, as being a myth, but unfortunately we are seeing this still to this day relatively commonly, in that even though individuals may live together for years or even decades, even if they are not married, they do not have what we call a common law marriage. There is still, to this day, still no such thing. Unfortunately, the institution of marriage exists, as I said, for a reason, and therefore, if you're not married, you are not married, or in a civil partnership. Sorry, I should also say. And so, as it says there, the reality is that there is no minimum period. I mean, you can be cohabiting for 70 years and you're still not married. So if your partner were to pass away, there is no automatic right to inherit in that basis whatsoever. And so, as we sort of touched on really earlier, the only way to ensure any sort of provision for a partner without a will is to either get married in the first place, so therefore they get the protections of a spouse. And therefore, if you were to die intestate without a will, your spouse is protected as they would receive the immediate statutory allowance for a surviving spouse, along with 50% of the remaining residue, or of course to draft a will and provide for them in an explicit set amount of your choosing. So really, there is only, again, those two ways to sort of provide for a partner in that way. Otherwise, that simply is not applicable.
There's also something called the spouse exemption, and again, that is only something which applies if you were married. So that's an inheritance tax exemption, which if you're living together for 50 years but unmarried, would not apply. So moving on to our next myth, myth number 4. So if I gift something, it is not included as part of my estate. It's something we come across all the time. People think that if they have an asset and it's not in their name, they transfer the name over, that it's no longer theirs because it's now got someone else's name against it. That isn't quite true entirely. So an example of this is people transferring large amounts of money to their children as a gift. That might be to buy a house or for any other reason, or transferring their property to their children. So just to cover all of those off, all gifts to individuals are potentially exempt transfers, is what it's called. And those can be free of inheritance tax if you survive 7 years. Now, there is something called tapering relief, which if you pass away within those 7 years, there's various dates and deadlines where that the inheritance tax can be tapered, but it is important to note that it only applies to the tax paid and it is not the amount of the gift which is tapered. People often talk about the 7-year gifting rule, and that is an extremely useful tool in planning. But if you gift your main property away to a child, so if you transfer the name of your property to your children, but you remain living in that property, that's called a gift with a reservation of benefit. And what that means is actually when you pass away, the value of your property will be included in your estate for inheritance tax purposes as if you had never gifted it, unless you are paying market rent. And there's some quite strict guidelines around that, so we'd recommend getting any advice if that is something you were considering looking at. But essentially that property would still form part of your taxable estate, so it's unlikely to obtain what you were trying to do by giving that away.
Exactly right, and that's one thing that many clients are very keen to sort of do, is sort of that phase before, thinking about their obviously ultimate demise, is that they're trying to remove assets from their estate. But obviously, if they were to gift their property but remain living there, they of course are retaining that use, and therefore they have not really created a gift at all. And that could be true of any other sort of asset that one may retain the use of. So it's something very much to get a lot of legal advice on prior to making any sort of gifts of that nature. Number 5 here, we have the classic DIY, I can do it myself, or certainly with perhaps now in the more modern age with the help of one of the various AI tools or programs to help that do it for you. And while that potentially may not be, well, I would certainly say not good advice currently. Who knows what the future may hold? But currently, there's a lot of issues with a lot of the online templates and AI tools that are producing wills. Certainly many of them are advertising at a click of a button, or certainly a 5-minute run through on some website. And I can't speak for all of them. You may be able to get some sort of document at the end that sort of would loosely roughly apply your wishes. But the issues that many are unfortunately finding, and many of my colleagues in the sort of contentious department would attest, is that not every aspect is often picked up by these various programs and AI tools to draft wills for you, and that really is obviously why, although you may say I'm biased, as of course I work in this area, that we have a role to provide, to give you all the necessary advice, both about your familial circumstances, your assets, your prospective tax liabilities, what sort of estate planning bits and pieces that you can put in place to achieve your goals, and leave your assets to your loved ones in a certain way, or not, or things like that. And therefore, a lot of these sort of automatic programs are very much not factoring all the various options in. Similarly, as we've seen with various budgets over the last few years, there's a lot of tax changes that are very much quite all-encompassing, and therefore whether these stay up to date and factor all that in remains to be seen. And so therefore we would obviously very much stress that everyone should very much get some advice when it comes to something as important as drafting your will, as of course once you're gone, you're unfortunately gone, and therefore it leaves it to everybody else to sort of pick up the pieces and clear up any mess that may or may not be there.
So another myth relates to guardians, which is someone who would look after your child if they're under 18 if you passed away before that point and both parents had passed away. So a lot of people think that I don't need to put any wishes in my will about who I'd like to look after my child in that particular event, and that the family can just agree that between themselves. The reality is that without a valid appointment of guardians in the will, there's often a lot of uncertainty about who should care for that minor child, and that can often lead to disputes and ultimately the court determining who should look after that child and be the legal guardian, which can be very stressful for family left in that situation, but it can also take a lot of time and cost to appoint that legal guardian.
Because as everyone was saying, what may be a very much an agreed thing between your family members now, unfortunately, could very much not be the case after you're gone. These disagreements can very much occur after your death. You may be absolutely certain that your family members are all on the same page until some new issue comes up, and obviously one can't factor everything in ahead of time, and so therefore leaving that to chance is very much not advisable, as a strict and formally appointed guardian is obviously going to be very much both in the interests of you, your family, and of course your children going forward. 7 here we have as long as you have a will from many years ago, you're still covered. And to an extent that is true. If you have a will validly executed, you do still have a validly executed will. However, depending on how old that will is, obviously you're potentially missing out on all the various changes, both legislative and tax related, that may have occurred since whatever date it was that you had your initial will formally created. And so there's a reason why we would say that it's very much in your best interests to sort of review your assets, your estate, your potential tax liabilities every sort of roughly 5 to 10 years, because that's quite a good chunk of life for things to change quite considerably. Children will obviously be born or grow older and become adults themselves. They may, they then get married themselves, and you may fall out with various members. You may come into some money, you may lose various assets. We can go on forever on that one. And so it's really quite important that to make the best use of all of the available reliefs, exemptions, tax planning options, and equally to make sure that actually your will is reflective of your current situation. Because of course, if you have a will from 30 years ago and you have more children or or grandchildren now, which aren't factored in at all, there is nothing really that it can be done. Your will, if it's executed, is the will that will be read and will deal with how to administer your estate. And therefore it's very important that you obviously factor that in and think about renewing your will, especially if one is, I would say, 20 plus years ago, one really must think about renewing, getting some advice, of course, and renewing their will to best make sure their will is up to date, an accurate reflection of their situation, and can make the best use, as I said, of all the available advice that there is to make sure your will is both tax efficient and applicable to your circumstances, because there's nothing that you can do once you're gone, as I've said.
So our 8th myth is that I don't need a will because it will go to my spouse anyway. And a lot of people think that because they're married or in a civil partnership, that everything will automatically pass to their spouse when they pass away, so that they do not need to create a will because actually that already is their wish. The reality of that is not entirely correct. So the intestacy rules, if someone does not have a will kick in. And it's that list of people who inherit the estate if there isn't a will. And under the intestacy rules, the spouse doesn't necessarily inherit the whole estate. They will only inherit the first, currently, £322,000 of the estate. Now, if that is the full estate and the estate is less than that, then the spouse would get all of that. But if the estate is over £322,000, then actually anything over that amount would be determined by the family circumstances. So, for example, if there are children, anything over that £322,000 would then be divided between the children and the spouse. So it would not be all of the estate that would pass to the spouse. The intestacy rules very rarely reflect people's true wishes, and they don't take into account tax planning objectives. So, for unmarried partners, married partners, it's really important to have a valid will so you don't end up in this situation where your estate isn't being passed to who you'd like it to.
So myth number 9 here. Having a will prevents disputes. Now, having a will certainly does help in some circumstances. There's some instructions as opposed to none whatsoever, but unfortunately, as we are possibly more aware, as these are filling our papers with more and more of these probate disputes, once you have a will, does not automatically preclude the ability for other people to make a claim against your estate. And so as much as it is, of course, excellent to have a will as opposed to not having a will and, detail your wishes explicitly, the reality, of course, of the situation is that a well-drafted will certainly helps reduce any uncertainty. Any advice that you get obviously also provides that sort of certainty that you have both the necessary capacity to make the will, understand your will, and therefore any sort of challenge on sort of capacity grounds or any other sort of thing like duress or other sort of points that may come up are obviously more covered off, as opposed to the more DIY situation that people may wish to go down. But the reality is that a claim against your estate can be made by anybody, and so obviously there are criteria in which that they have to fulfill to follow that up. But simply having a will does not automatically preclude your estate from having anyone make a claim. Whether it be successful or not obviously remains to be seen as to whether or not what sort of evidence they can provide of what actually their claim actually is, whether it's for greater maintenance or whether the will is invalid due to, as I said, raft of potential options such as lack of capacity or misunderstanding or some sort of duress from a family member, etc. And so obviously having a will is, of course, the first step to sort of highlight one's wishes and to detail how and much is their estate to pass, but it doesn't automatically mean that then no one can make an estate. That's not simply a facet of an intestacy whereby people can make claims because there's no will, and therefore everyone sort of gathers round and tries to get their piece. Having a will does not protect you from that scenario.
So our final myth for today is that my partner can make decisions for me if I lose capacity. So this is a very common one that I come across, and a lot of people assume that because either you're married or with someone for a long period of time, that person will be able to look after your finances if you need them to, for example, go to the bank for you, and that's automatic, that they can step in and give you that helping hand. And that isn't strictly true. So neither cohabiting partners or married couples, which surprises a lot of people, don't have the authority to make decisions about finances or health decisions for their partner, even after they've lost capacity. So without a registered lasting power of attorney or an enduring power of attorney, that partner will not be able to go to the banks, discuss things with investment providers, discuss options with healthcare professionals, or any other institution, because technically and legally they don't have the authority to be able to discuss that person's affairs. So if there is no lasting power of attorney in place and the person loses mental capacity, so they're unable to make their own decisions anymore, then those family members who are trying to help that person would need to make an application for a deputyship order to the Court of Protection. This is a far more costly and time-consuming route, and certainly one to be avoided if you can. So it's highly recommended to make lasting powers of attorney whilst you both have mental capacity, are able to do so, and it makes things a lot smoother down the line should you need to help one another in the future. Having that lasting power of attorney also makes it very clear about who you want to make those decisions for you. So it wouldn't be the court deciding who would be best, it would be you deciding that you want a particular person to make those decisions for you in the future, should they need to. And that can be anyone, whether you're a married partner, it could be them, it could be children, could be an unmarried partner, friends, anyone that you choose. They will need to agree to it. So they would need to sign something as well to say that they are happy to do that. But that's all encompassed in creating lasting powers of attorney.
And that really wraps things up, because that's our quick little fire run through of sort of 10 very common myths that members of the general public seem to hold on to in regards to both will preparation, estate planning, and a little one there on the end about lasting during powers of attorney regarding capacity points there. So hopefully that has been useful to all of you, and it's been a little quick run through of what some of those myths are, the reality, and really what the best next steps and preparation you can take in order to sort of make sure you don't fall foul of any of those. Here's a few last pane, of course, but details of ourselves. So that's of course me, solicitor in the private wealth team here. There's some of our contact details there, along with my colleague Emily Southwood there as well. And so should you have any queries further on any of those points, or would like to get further advice on anything we've discussed, whether that's wills, estate planning, probate for a loved one who's already passed away, or powers of attorney for yourself or spouse or whatever it might be, please do get in touch, and we would love to assist.
Thank you.
Thank you very much for attending today.